Hello students, and welcome back to yet another session of Judiciary. This is the very first unit of our class 12th legal studies, and today we will be studying about role of courts. The role of these courts along with their composition, power and procedure of functioning is elaborated in our constitution. And very first thing we will study under it is Supreme Court. Different roles of Supreme Court of India. The Supreme Court of India primarily exercises the role of an adjudicator and interpretator. What do we mean by adjudicator? By adjudicator we mean someone who gives a formal decision, right, or a judgment. And what do we mean by interpretator? One who interprets, right, or elaborates or explains, right. In this case, Supreme Court interprets Constitution mainly. Article 32 of the Constitution further gives an extensive original jurisdiction to the Supreme Court for the enforcement of fundamental rights of the citizens through issuing directions, orders and rights. This is popularly known as right jurisdiction of the court. So there is another role of Supreme Court in which Supreme Court have to protect the fundamental rights and other legal rights of citizens. This is known as right jurisdiction of the court. The appellate jurisdiction of the Supreme Court can be invoked by a certificate granted by the High Court. These cases must involve a substantial question of law as to interpretation of the Constitution. Now, third major role of Supreme Court is appellate jurisdiction. Under this, if you are not satisfied by any of the judgment or decree of High Court, then you can go to Supreme Court. But whether it is civil matter or a criminal matter, there should be substantial question of law as to interpretation of Constitution. Then only you can invoke this appellate jurisdiction of Supreme Court, right. Apart from the listed appellate powers of the court, the Supreme Court also vested with wide appellate jurisdiction over all courts and tribunal as provided in Article 136 of the Constitution. Under its discretion, the court may grant a special leave to appeal and receive any judgment, decree, determination, sentence or order in any case or matter passed or made by any court or tribunal in the territory of India. Now again, Article 136 provides a special power, say it's a kind of a special power, appellate power, under which you can make appeal even if the last judgment was not from High Court. Okay? In easy words you can understand it like this: appeal against judgment of or degree of any other court or tribunal other than High Court, right. Supreme Court also functions as an advisor. Court's advisory jurisdiction may be sought by the President under Article 143 of the Constitution. This procedure is termed as presidential reference and is recognized as the advisory jurisdiction of the court. Now, another role is of advisory jurisdiction, right. Under this, President can ask for advisory on any matter and Supreme Court have to give advice, right. Now the point to remember here is Supreme Court can refuse to provide its advisory opinion if it is not satisfied that the questions are either socio-economic or political in nature. Now there are cases when Supreme Court can refuse to give its advisory under its advisory jurisdiction when it is not when Supreme Court thinks that the matter in concern is not of its league, it's not concerned with a law or constitution, but it is related to maybe some socio-economic matter or political matter. In such situations, Supreme Court can deny. Supreme Court has relaxed its locus standi and has permitted public-spirited citizens and civil society organizations to approach the court on behalf of the victims for better administration of justice. Now, what do we mean by locus standi? Locus standi is the right of the person to be in court, to reach the court we can say to reach the court or seek for the judgment, we can say. What does this point in easy language refer to? It refer to PILs, right? In this point says that not necessarily the victim needs to take a stand, but third party can come up. People who are public spirited citizens and want to help society to grow, they can approach on behalf of the victim and can seek for the better justice. The court has in its own initiative started cases of public importance. Now, court itself can ask matters, handle matters, or make issues and resolve issues of public importance. Now, recently you must have witnessed some of the situations जिसमें Supreme Court ने दखलंदाजी दी, Supreme Court ने कहा, ठीक है, this is when court thinks that something is related to public importance and they should interfere in it. The first ever PIL is listed as Husnaira Khatun versus State of Bihar and dates back to 1979. Now, what was this case? Husnaira Khatun case was actually a PIL. This is considered to be the very first PIL, and this was for the inhuman condition of prisoners in Bihar. Now let's have a glance on the characteristics of PIL. PIL can be termed as non-advisory litigations rather than focusing on traditional litigation of advisory characteristic. PIL are recognized as tools for social change. Now, what is advisory characteristic or advisory? When there are two people, two parties in opposed to each other. Whereas in PILs there are not two parties. Instead, the spirit of PIL is to seek for the better justice and to bring social change, recognized as a tool for social change, right? It's not a normal case where there are two parties involved in pointing out fingers at each other, opposing each other. Instead, it is only and only to bring a better justice, to improve the social economic conditions. PILs are based on the tenets of citizen standing and representative standing, which expand the right of third party approach to court. The PILs are based on that third party can come up and seek for better justice on behalf of others. Okay. PIL from its inception is modeled as remedial nature, which aim at creating a dynamic welfare oriented model of judiciary. Now, PILs are considered to be remedial in nature and they are to here create better judiciary, better justice and better society. PIL from its inception, right from the concept of PIL, the aim is only for creating better judiciary. Okay. Now, PIL further strengthens the role of judiciary as a monitor and watchdog agency. How does PIL help in this role of judiciary? Now, people are afraid while doing anything that there can be a PIL. There are chances that Supreme Court or court will neglect the issue, or it's not possible for judiciary and handful of people involved in judiciary to keep eye on each and everything. But PIL is a kind of tool जिससे अगर आपको लगता है कि जो हो रहा है वो गलत हो रहा है तो आप भी जाके इनिशिएट कर सकते हैं और एक तरीके से जुडिशरी को हेल्प मिलेगी देखने में कि हाँ भाई कहाँ कहाँ गलत चल रहा है. ओके, सो इस तरह से इवन द रोल ऑफ वॉचडॉग, this role is also more strengthened. However, with the development of growth of PIL, they also have been misused for private gains and led to frivolous litigations on unnecessary issues. Now, it's not a characteristic, it's the demerit. And now, as PILs have grown, the concept of PILs is growing day by day. People are misusing it, firstly. Secondly, it is also said that some people believe that through PIL, Supreme Court is trying to take over the work of legislature. Right? Let us ponder. Are PILs replacing or supplementing the role or supplementing the role of legislature, which is the primary law acting organ in India? What are your opinions? Discuss it with your friends, with your family, parents. It's a very common issue. A lot of people have an opinion about PILs, and let us know through your messages or comment or in the comment section. This was a very small topic but a very important topic. Read this and do read it from your book also. Prepare for it.